Doctor, looking back on what happened here, can you think of anything you could have done differently that would have prevented my client's injuries? Objection, the defense attorney says. You want to know why the defense attorney is going to go crazy if I ask that question? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. During the pretrial process, I have an opportunity to question doctors that we sue in a medical malpractice case. And now, during the course of questioning the doctor in their attorney's office, I will often ask questions about what were the standards of care in this type of situation. I will then ask the doctor hypothetical questions about if certain things were not done. Would you agree that that would be a departure or violation from the basic standards of medical care? And now, what I call a throwaway question. Doctor, as you sit here today, is there anything looking backwards that you would have done differently or could have done differently that would have altered or changed my client's outcome? Objection, you can't ask him that. The defense attorney is going to come right out and say, listen, you can't ask a doctor today, years later, whether he would have done something different if he could go back in time. The fact is, we can't go back in time. You can ask him what he did, you can ask him what he was thinking, you can ask him lots of stuff surrounding the events that occurred. But now, 2 or 3 years later, you want to ask him if he could have done anything differently, would that have changed the outcome? You can't do that. I'm directing the witness not to answer the question. Wow, that's a loaded legal argument. Not only that, but the last thing I told you, doctor, do not answer the question. An attorney in New York can't do that during the course of a question and answer session known as a deposition. There are only 2 instances where an attorney can tell their witness not to do that. And that is if something is so palpably improper and so off-the-wall crazy, unrelated to the claims or the defenses in this case, then the defense has a right to turn around and say, doctor, don't answer that question. It's totally inappropriate. The other instance where the attorney has a right to tell the doctor not to answer that question is if it calls for something that's privileged. Doctor, tell us what you and your attorney talked about. Objection, that's privileged. So the mere fact that I would love to learn what the doctor thinks now, years later, about whether or not he could have done something differently, that might give me an insight that I might, if I get a good answer, try and use at the time of trial. But even if I do get a good answer, you can bet that during the course of trial, the defense attorney will raise a big stink, will raise a big objection, and throw the judge a big legal argument why that statement and that testimony that was given years earlier should not be allowed to come in during the course of trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you probably have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.